thank you, Inke, and it's an absolute pleasure to be here, but also a pleasure to support the very valuable initiative, so I was very, very happy to support this event. Thanks so much for also inviting me to give a keynote speech and to discuss a topic that is very close to my heart, but also it's really the focus of my current research under the European Research Council project that I run on state silence. You can see that we have created also a website, and you can see all our activities, what we do, our research, and all the research outputs that are already out, and some of that are forthcoming, and most of them are open access as well. So today I will talk about ascribing a voice to silent states, and I'd like to share with you some of my ideas and reflections on a new thought that I've had about differentiated legislative responsibility. But let's start with how international law is made and why silence and silent states are important in international lawmaking. So international law is made through the interaction between states, the main subjects of international law. And in this process, courts and scholars place particular emphasis on the actions of states, the verbal and physical actions of states. However, the silence of states, namely the physical and verbal inaction of states, plays an important role in international lawmaking, but it has been unduly, in my view, overlooked in international law scholarship. Now, different international lawmaking processes are premised on the silencing and marginalization of numerous actors, for instance, indigenous peoples, colonial colonies, or even individuals, do not have a voice that counts as relevant for the creation and change of customary international law or for the interpretation of treaties. And in addition, the voice of some states may frequently be excluded. An example is the fact that the voice of the 5 permanent members of the United Nations Security Council is consistently instrumental in shaping and adopting the binding peace and security decisions of the Council, to the exclusion, of course, of the voice of other states. But international law also ascribes a voice, a meaning, to the silence of states, and it does so especially through the concept of acquiescence, namely that a state is taken to accept when it remains silent in the face of a situation or a claim that threatens its rights. In 2008, in Pedra Branca, that's a case between Malaysia and Singapore, the International Court of Justice stated that silence may speak. So the court itself has actually said that silence can have a voice in order to describe acquiescence. Now, Pedra Branca was a dispute about sovereignty over a particular territory, and the court's reasoning in this case concerns acquiescence for the purpose of territorial title, so who has sovereignty over a particular space. However, because acquiescence is relevant for the identification of custom as well as the formation, interpretation, modification of international agreements, it affects all primary rules of international law, from trade law, law of the sea, human rights, use of force, so on and so forth. And it is on this latter legal significance of state silence that I will focus today. Now, the one, and more specifically, the voice, the specific voice, that of acceptance, that is ascribed by international law to silent states. Now, how, however, does this silence, state silence, relate to issues of inequality? Now, under international law, from a point of view of international law, in terms of formality, all states are equal. However, in reality, states differ significantly in their political structure, geopolitical positioning, their military power, and importantly, their economic, technical, and institutional capacities. Now, some developing countries have a handful of legal officers in the ministries of foreign affairs in capital, and they may have one or no legal officer, for instance, in their mission in the United Nations. For these reasons, they may be focusing on 2 or perhaps three areas of international law that are of particular interest to them, but that means that they are silent in relation to a vast areas of international law. Conversely, in most areas of international law, developed states can be the drivers in international lawmaking, while economically poor countries are likely to be silent and to be taken to accept to the practice of the developed countries because they have less economic and other capacity to object. Now, in the following minutes, I would like to unpack how international law ascribes a voice to silent states and what options perhaps we have if we wanted to address economic inequalities in this respect. So I will structure my talk as follows. First, I will explain the conditions under which state silence is given the meaning of acquiescence in international law. So I will discuss doctrinal law, and specifically I will focus on the requirement that a state has to be in a position to react. The second thing I will do is to discuss why it is important in practice whether the threshold of being in a position to react within the rule of acquiescence takes into account the economic, institutional, and technical capacity of each state. Third, I will argue that the reasoning behind the rule of acquiescence is that all states bear legislative responsibility, and in a sense, this is a due diligence obligation. And fourth, I will reflect on two options through which doctrinal law can take into account the different capacities of states. And finally, fifth, I will draw some conclusions. So starting with...
I think it's just a test, but I'm not sure.
No, I think it must be a test, yes. Let me pause for a moment. I think it's okay. Yeah, stop. So, it stopped, so we're safe. Yeah, so starting with the conditions under which international law ascribes the meaning of acceptance to the silence of states. So acquiescence has been recognized in international case law, an example of a case that I just discussed, the Pedra Branca case, but it also has been very recently been recognized by the International Law Commission. The International Law Commission is a subsidiary of the organ of the United Nations General Assembly, and it has been mandated with the progressive development of international law and its codification. That means that its work is not binding per se, but it can reflect existing law, or it may guide the future development of the law. Now, why is this important here? In its 2018 conclusions on identification of customary international law, the Commission stated, and allow me to quote this, failure to react, i.e. silence, over time to a practice may serve as evidence of acceptance as law, so belief of law, provided that states were in a position to react and the circumstances called for some reaction. And the Commission has taken exactly the same position in its 2018 conclusions on the subsequent agreements and practice in relation to the interpretation of treaties. And here the Commission was concerned with the rule that is set forth in Article 31.3b of the Vienna Convention on the Law of Treaties. Just for those among us that are lawyers, I'm citing the particular article, but let me explain what this rule is about and why this is important. So this rule stipulates that the interpreter of a treaty has to take into account the subsequent practice of some parties that establishes the agreement of all parties about the treaty's interpretation. Now, to identify how an agreement between all parties can be made only through the practice of some, the Commission has stated the following. Silence may constitute acceptance when the silent state is in a position to react and the circumstances called for some reaction. Now, the circumstances that call for some reaction concern a consistent legal claim over a period of time made by another state. Now, the requirement that a state is in a position to react includes two aspects according to international case law. The first one is that you have knowledge of the circumstances that call for your reaction. The second one has to do with the silent state having the ability to react. And particularly, case law has focused on whether the state during that critical period of being silent was in fact embroiled in a civil strife or an international armed conflict. The most recent case that has recognized this is Somalia versus Kenya in 2021, just a few months ago, where the court dealt with a dispute between these two states about maritime delimitation, and it considered that Somalia's silence during the civil war could not be taken as acceptance because it had not had the capacity to react. However, neither case law nor the Commission's work consider whether the standard that a state has to be in a capacity to react takes into account the economic, technological, and institutional capacity of a silent state. And this brings me to the second question I want to address. Does it matter in practice whether this threshold of being in a position to react within the rule of acquiescence takes into account these differences in terms of economic, institutional, and technical capacity? So I will give you two real-life examples. The one is a bilateral setting that comes from the era of colonialism, and the other one is a multilateral setting that is a modern one. And both are real examples. Now, starting with the bilateral setting, the case before the International Court of Justice concerning the Temple of Prech-Vihear. This was a dispute between Cambodia and Thailand relating to the occupation by Thailand of a piece of territory surrounding the Temple of Prech-Vihear that Cambodia claimed was under its sovereignty. So they had a dispute about whether this temple was in Cambodia or actually belonged to Thailand. The applicable law in this dispute was the 1904 Franco-Siamese Treaty. Cambodia at the time was a protectorate of France, and Siam, today Thailand, was the only state in that region that did not become a protectorate of any colonial power, but was trying to avoid subjugation. The 1904 Franco-Siamese Treaty provided that the frontier between Siam and Cambodia was to follow the watershed line. Now, the treaty established also a mixed delimitation commission that was composed of experts that were Siamese and French. And these were charged to delimit the frontier in various specific districts. Now, the final part of the delimitation process involved the preparation and publication of maps. That's the usual practice in terms of delimitation. Because Siam lacked technical capacity, we're talking about 1907. Imagine this for a moment, a colonial power and a state that was in 1907. I don't think we can compare it to anything that could be today perceived as a developing country even. Siam lacked technical capacity, and the Siamese colleagues in the commission asked their French colleagues to prepare the maps because they had the capacity, right? And that was done. France prepared, arranged for the maps to be done. The critical map set a frontier that departed from the agreed watershed line that was agreed in the 1904 treaty and indicated that the temple, Prech-Vihear, was in Cambodia, i.e. the French protectorate. This map then was sent by France to Siam, to the Siamese government officials. Now, in 1952, the court decided that because Siam did not object to these maps, Siam had acquiesced to an interpretation of the 1904 treaty that departed from the initial agreement. So what type of inequalities are lurking here, and which, frankly, were completely ignored by the court? The first one is obvious. I think it's the technical capacity issue. Siam relied exclusively on a major colonial power in order to be able to have some technical capacity for the maps. And the second thing that was lurking, but it became obvious in the pleadings, and the court did not really address this matter, is the military disparity. Siam was concerned that France could invade it at any time if it wished to. So had the court taken into account these inequalities when it considered whether Siam was in a position to react, it is likely that it would have not concluded that Siam has acquiesced to a change of the treaty provisions. In other words, the tempo today would be in Thailand, not Cambodia. So whether the economic, technical, and institutional capacity of a state is taken into account in the thresholds of acquiescence does matter and can be, in fact, determinative in relation to subject matters that are fundamental for a state, including in relation to who has sovereignty over a particular territory, extremely close to a state's heart. Now, let me move on to the contemporary multilateral example I want to give you. 2018, I'm sure everyone will be aware of this, the US, the UK, and France bombed Syria in response to the use of chemical weapons against civilians by the Assad regime. Now, among these three states that used force, only the UK has made a legal claim that humanitarian intervention was the ground on which it was acting, and that on the basis of that ground, the use of force was lawful. So the UK is making a legal claim that today, humanitarian intervention is a ground for permissible use of force, okay? Now, numerous other states remain silent. Does this interaction between a legal claim by one developed state and the silence of numerous other states, including numerous developing states, mean that custom and the Charter of the United Nations has now changed and permits humanitarian intervention? This modern example demonstrates that if the silence of states is taken as acceptance, it has the potential to erode fundamental rules of international law, such as the prohibition of use of force. But for states that have less economic capacity than developed countries, the problem in this context actually is even more focused, and allow me to explain this. Today we have 190 states, or frankly, we have more than 190 states. And in addition to this, communications are easier, and states can make their legal claims public through not only not verbal, as the very traditional way, they can do so by publicizing them in the Ministries of Foreign Affairs websites. They can do so through international organizations. And frankly, today they can even do so on Twitter. So developing countries are unlikely to be able to keep up with these public claims of so many states at the same time, and are likely to be silent and to be taken to accept changes in the law. Now, in order to reflect on what options do we have here at our disposal in order to address the fact that different states have different economic capacities, it is necessary, I think, to first understand the reasoning behind the law. Why do we have a rule of acquiescence in international law that is relevant for custom formation, for treaty change, treaty interpretation? So in my view, acquiescence is a rule that is a rule of presumption. That means that it connects a basic fact, here state silence, with a presumed fact to be true, to be taken to be true. Here, state acceptance. So it connects these two facts, a basic fact and a presumed fact. Now, all rules of presumption are biased. They favor a particular presumed fact over another. And here we're favoring acceptance over lack of acceptance. But why? Why do we do this? Now, two reasons can explain this in international law. The first one is probability, and the other one is acceptability of error or normative consideration. So let's start for a moment with probability. It could be argued that in most cases where a state is silent in the face of a consistent and clear claim against its interests, it actually and really accepts. But probability is insufficient to explain this bias towards acceptance, and this is because there may be cases where the reason behind silence is not acceptance. So it can't account for all cases. A normative justification is necessary. And the normative explanation here is acceptability of error. In other words, we accept the possible error that the silent state might actually not be truly accepting here, because there is a goal that is more valued. And here the law values two major goals. The first one is predictability of law, and the second one is avoidance of impeding the change of the law in the future. So we have to allow both predictability but also allow the development of the law if it is necessary. Now, this reasoning behind the law suggests that all states bear legislative responsibility. Since the distinctive feature of international law is that it is decentralized as a legal order, in other words, it is made through the interaction between states, states bear a due diligence duty vis-à-vis norm creation. The moment they become states, they have to be acting diligently in relation to the development of the law. If they are silent in the face of consistent legal claims which create norm volatility, their silence counts as acceptance in the international lawmaking process in order to preserve predictability and preserve at the same time some space for developing the law. Now, having shown that it matters whether the requirement that a state is in a position to react takes into account the different economic capacities of states, but also why the rule of acquiescence exists in international law, I move to what options are available if we decided to include within this requirement some considerations of differentiated economic capabilities between states. And I have come up with two models, or perhaps I've thought of two possibilities here. The first one I call average state model. And second, what I call the more pure, differentiated legislative responsibility model. So let's start with the average state model. So this threshold, the threshold of being in a position to react in the rule of acquiescence, would be a fixed standard, and that would be the ability of the average state. This option is inspired by domestic laws, which sometimes incorporate the average person on the street standard in order to assess reasonable conduct. The advantage of this approach is that it ensures a harmonized application over time to all states. And in addition, it ensures that the capacity of a state would not be measured by reference to what the most powerful state would be. However, I think at a closer glance, a few challenges arise, and I have identified two of them. First, what is an average state? Should we, first of all, identify it by reference to economic criteria? And what method should we employ? Should we, for instance, use the GDP of a state that stands in the middle if we rank all states and their GDPs? Or should it be by reference of how many civil servants it employs, or how many legal advisors it has in its Ministry of Foreign Affairs? In addition, I think we cannot really find the average state in relation to all subject matters of international law. Different states may be more able or less able to react in relation to legal developments in different fields. Let me just give you an example. The United Kingdom, for instance, is particularly interested in cyber operations, and it might have developed more capacity in relation to the law in relation to cyber operations than island states, Pacific Island states, for instance. But Pacific Island states are much more interested in sea level rise issues than the United Kingdom. And so they may have more capacity, and they may focus in their practice much more and their focus of and attention to issues of sea level rise. So I'm not so sure that we can in fact find an average state across the board in all areas of international law. And second, and more fundamentally, if the objective behind adopting the average state capacity is to address the mismatch between equality in law and inequality in the real world, I think that this standard fails to meet its own objective. And the reason is the following. The law is still, will still expect some states to perform at a level that exceeds the real capacity, because we're taking the average state. So some states fall under that average, and they have to, in reality, then perform higher to what they can do. So for these reasons, I think that this particular model most certainly has its challenges. And these challenges point to a more differentiated model. So I call this the differentiated legislative responsibility model. And this would allow for differentiation between developing countries and developed states, but also among developing countries and among developed countries. This is inspired by the due diligence obligation in numerous fields of international law, such as international environmental law, climate change law, human rights law as well. And the justification behind it is substantive equality. Because formal equality between states does not represent reality, it leads to substantive inequality when it comes to lawmaking. So less powerful states are more likely to be taken to have accepted, comparing to more powerful states which have the economic and institutional capacity to react. Now, the advantage of this approach is that it recognizes that all states are subject to a rule of acquiescence. They all bear due diligence duty, but also that each of one of them has different capacities to react. So all of them have due diligence obligations, but at least in accordance with their capabilities. Now, however, this approach still has a few challenges that it's facing. And I have identified three, but I would really like to hear from you as well in terms of what you think about the challenges in relation to both of these options, obviously. Now, the first challenge I've identified is that, again, how would capacity to react be measured here? Even in areas of international law that I just mentioned, international environmental law, climate change law, human rights, it is unsettled how to assess capacity. Is this only about economic capacity or not? And even if we focus on economic capacity exclusively, by what measure are states to assess the capacity of other states to react? And these standards are obviously unclear at the moment. And second, and crucially, differentiated and unclear standards may undermine the capacity of the law to govern behavior. When rules lack, and apologies, and that's because they give plenty of leeway to those interpreting and applying them. So anyone could then, at any point, suggest, well, I didn't have enough capacity, so I'm not really bound by this. So Thomas Frank had emphasized that states comply with legal rules when these are certain, clear, and determinate. When rules lack these characteristics, they lose their compliance pool quality. And let me just give you some questions so that we understand what the problems of a state would be in this case. So how would a state know whether any one state of the 190 states has the economic capacity to react in relation to custom or treaties in any area of international law? How would a state know, in other words, what the law is at any point in time? So there is a real danger, I think, that international law across different fields would be undermined by such a differentiated approach. Nor would I, and I think that's actually important to consider as well, I do not think that this necessarily would be beneficial for less powerful states, because more powerful states thrive in determinacy. They have more space to exert pressure when legal standards are unclear. And the third reason to reflect on a challenge here would be actually the third world approaches to international law. These also caution, or rather call for caution here, because a differentiated capacity model in reality undermines the formal legal equality between states, which to some extent is a big accomplishment for developing countries. And if we accept differentiated standards, these may be presenting smaller and developing countries as the lesser relative in a community of nations. So this is something as well that we ought to be considering in this discussion. So to conclude, there is no perfect answer, I think, about how international law deals or should deal with the real inequalities between states, including in relation to ascribing a legally relevant voice to the silence of states. However, being aware is warranted if we want to make international law less hegemonic and more inclusive. And by this I mean that we ought to be aware of our basic assumptions as international lawyers or political scientists or those colleagues that work in international organizations, but also of the need to ensure predictability in international law, the real challenges that many states face in the process of law creation, and the mismatch between legal equality and real capacities. So, and with this, I thank you very much, and I look forward to our discussion.